Jason Derulo is being sued by singer Amaza Gibson, who says he sexually harassed her and sabotaged her music career when she refused his advances. He denies all wrongdoing, but this case is a good example of how employment discrimination and harassment really play out in the real world. The lawsuit claims that Derulo reached out in 2021 with a dream recording opportunity under his joint venture with Atlantic Records and his label Future History. Gibson says that once she signed, he subjected her to unwanted advances, pressured her to drink, and engage in degrading sexual conduct to make it in the industry, and turned hostile when she refused. She alleges sexual harassment, discrimination, retaliation, hostile work environment, breach of contract, and emotional distress. In plain terms, she says her releases were stalled and her contract was eventually terminated because she would not go along with what was being asked and because she complained. Now here's where a lot of people get confused. The first case in California was dismissed. That does not mean a judge said none of this happened. The court said California was the wrong place to file because the contract had a form selection clause requiring disputes to be brought in New York. That's a technical procedural dismissal, not a ruling on who is telling the truth. After that dismissal, Gibson's legal team refiled in New York with a new detailed complaint under New York law that restates the harassment, discrimination, and retaliation claims. Her lawyers were very clear that the case is active and moving despite public comments suggesting it was thrown out. So, what should employees learn from this? First, procedural rules matter. Where you file and what your contract says about venue and choice of law can decide whether your case is heard at all. If your contract says disputes must go to another state, that clause can control your entire legal strategy. Second, harassment often comes wrapped in opportunity. When a boss or powerful person ties your career, visibility, or releases to whether you go along with sexual advances, that's classic quid pro quo sexual harassment, and if you're punished for saying no, it's retaliation. Third, reporting matters. When you push back, complain, or refuse to participate, what happens next can build a retaliation claim. If you get stalled work, cold treatment, broken promises, or termination after you speak up, you may have an additional claim. If you see yourself in this story, here are practical steps. Keep everything in writing: contracts, DMs, emails, texts, voice notes, and calendars that show what was promised, what you refused, and what changed afterward. Know what your contracts say about where lawsuits must be filed and which state's law applies. And talk to an employment discrimination or civil rights lawyer early, before deadlines or venue issues limit your options. I'm Kyra Fontenot, and I'm an employment lawyer. I only represent employees. Make sure you're following me so you know exactly what to do if you ever face this kind of discrimination at work.